The next matter to come before the court this morning is in re IT. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning. I'll keep your price and passage of time. We've read the briefs on the this evening.
Good morning. May it please the court, I am Derek Check on behalf of the appellant, Robert Townend, and I would like to reserve 3 minutes for rebuttal. The case this morning is an appeal from a juvenile dependency proceeding from the adjudication stage. Long brief from the appellant. I think I can condense it down and make the decision very simple for the court. The issue in this case is, does the law permit prospective dependency under Section C of 2151.04? And the answer to that is simply no. The trial court allowed that to proceed, however, the law does not support that. And there is nothing out there that sustains that you can have prospective dependency under Section C. The Ohio Supreme Court has specifically said that you must show an actual adverse impact on the child to have dependency. Prospective dependency, this idea of it, is allowed by the General Assembly under Section D of 2151.04, and several courts of appeals have raised this idea. However, the court that really started this was, I believe, the Massengill case out of the 6th District. And in that particular case, the court said, a juvenile court should not have to wait until a child is harmed before it can find the child's environment adverse and find dependency. The problem with that case was the mother in that case had a baby. The baby tested positive, I believe, for cocaine. And so there already was an actual adverse impact. It wasn't prospective in that case. It was an adverse impact. That case actually, I believe, predated In re Baby Girl Baxter from the Supreme Court, which said that when a parent has a child and the child was born with drugs in its system, it is per se abused. So we have passed that stage, and this idea of prospective dependency that keeps getting circulated around does not exist. It's a fiction, and this court can provide an answer to that and clarify it to the juvenile courts in this district and say there is no such animal under Section C of the code. Now, the other issues that have come up in this case, there's a couple of broad issues. The major issue was the admission of a psychological evaluation of father that was done in a companion juvenile case. That admission of that evaluation, as well as the testimony from the psychologist, was inappropriate, and there were several reasons for that. First of all, the psychologist wasn't actually a licensed psychologist.
On that point, her supervisor signed the report.
Correct.
What is the case law in that regard? I mean, that's a rather common situation.
Well, I think the case law in that would be with respect to two things. I mean, number one, the question is it a hearsay document? And the business records exception could apply there. The problem is that in juvenile cases, we don't just look to see if something comes in under the business records exception. We have to look, in this case, where there's a Fifth Amendment issue, and there's also a Juvenile Rule 29 issue. And this is one of the issues raised by the trial court. The trial court brought up this case of I think it's Fisher. The Fisher case was a 42 U.S.C. 1983 civil rights action. It's totally different than what was before the juvenile court. I think the citation just is totally wrong by the trial court. The other case raised was United States versus Doe. Doe does not say what the trial court thought it said. Doe specifically says that compelled production of documents can be privileged. That's the U.S. Supreme Court telling us that. That case was an argument over production of documents pursuant to a grand jury subpoena and what types of documents can be produced and whether there's a statutory immunity that should be granted to compel that production. It wasn't a blanket assertion that any time you write something or sign something, it can come into a court of law. And that's essentially how the juvenile court treated this here. The psychological evaluation was done pursuant to a case plan in another case, so it was court ordered. There was no voluntary release of this information, unlike the case in U.S. v. Doe, where the person who was trying to quash the subpoena had produced information voluntarily as part of his business. He was creating business records, and those were being subpoenaed. In this case, we're looking at a court-ordered evaluation that was being brought in over the objection of the parent. So I think it's clear that those are very distinct animals, and we can't classify them in the same class and say that Doe tells us that this is allowed in. It violates his Fifth Amendment privilege. If we allow a parent who's court-ordered to comply with an assessment under the penalty of contempt to then come in and we can introduce a document that's created from that evaluation in a later proceeding with his statements, admissions, he could have admitted to a crime in there, we're now running afoul of the Fifth Amendment. Juvenile Rule 29 also tells us that a parent has a right to be silent at an adjudication. They do not have to testify if they choose not to. Again, if we're going to allow documents which have testimonial statements of a parent to come in from another case, another proceeding, then essentially we're allowing the parent or forcing the parent to testify over their right to remain silent on the proceeding. The other thing I want to point out to the court, which is I think an issue that totally eluded the trial court, is there is a statutory exception to the physician and psychologist patient privilege, which is 2317.02b. That statute specifically lists the exceptions in when the privilege can be broken and a physician or psychologist can be compelled to testify in court. That statute is very clear about the limitations of when a psychologist can testify. What I want to point the court to, which the trial court missed, was the exception at issue is 2317.02b1b. The very first part of that exception says, in any civil action concerning court-ordered treatment or services received by a patient, comma. That comma is the most important comma in the entire paragraph, because the entire exception is contained in that first phrase. Everything that follows it is a modifier on that first phrase. First point on that is it says civil action. And action is just not an arbitrary word that carries a dictionary meaning. It is defined by statute in the code. And it is defined to mean ordinary proceedings in a court of justice. They can be criminal, however, in this case the legislature said civil, so we know we're talking about civil proceedings. What this is really talking about is tort actions and breach of contract actions. Juvenile proceedings are special statutory proceedings. They're defined under 2505.02. They are not the same as an action. They are very different animals, and I refer the court to the Ohio Supreme Court case in the brief, where the Ohio Supreme Court defined essentially what is an action and what is a special proceeding. This exception, even though it talks about juvenile records and it talks about the fact that there are court-ordered case plan services and that there could be abuse, neglect, dependency proceedings or temporary custody proceedings, all the exception essentially is saying is that these records can come in and a physician or a psychologist may be compelled to testify about court-ordered treatment or services relating to juvenile matters in a civil action, meaning a tort, a breach of contract, anything that's defined as an action, not a dependency proceeding. That point was entirely lost on the trial court. The other issue that we have in this case, we have an issue about admission of some business records from Coleman Behavioral Health. The custodian of those records came in and she testified that she was asked a few questions. Problem is she did not testify to all the essentials to meet the business records exception. There's several distinct points. This court's elaborated them in its prior case law. Those points were not met. And so the records were inadmissible. They were objected to. They certainly were prejudicial because the trial court relied on them in its opinion. Likewise, we go back to the psychological evaluation. There was also a business records exception there. There's a problem as well because that exception requires that the custodian or a person, other qualified witness testify to the records and to allow the admission. The problem is that Dr. Obradovich was not the custodian, and she was not a qualified witness. The reason she wasn't qualified was because she is not a licensed psychologist. She can't testify to a psychological evaluation or report and talk about whether it was properly constructed, whether it was kept in the ordinary course of business, because she doesn't have the licensure, the standing to do that. That's why the legislature has required that certain professions in this state have to be licensed, so we know good from bad. And so to be qualified, you either have to be the custodian or someone who has the standing, licensure is another word we can use, to bring that record in.
So that person could be a non-physician who is custodian of a report signed by the doctor who is not licensed.
Correct. And the reason being is that some agencies and organizations designate one person as the custodian or keeper of all their records.
So the dispositive issue is not that she wasn't licensed. It's merely that she wasn't the custodian.
Well, I think it's both. It's that she was not the custodian and she was not licensed.
But she worked under the supervision of a licensed physician.
Well, presumably, we don't, the only thing we know in the record that tells us that is we have a psychologist's signature on the end of that report. And we don't know exactly how this report was created, because that's not in the record. We don't know the manner, whether it was made contemporaneously, whether it was done in the ordinary course of business. So all that's missing from the record. The other major issue in this case is the venue issue. This issue is pretty simple, contrary to what Children's Services would have you hear. Venue, basically, at the adjudication hearing, there was never a question asked about where do the parents live. There was some testimony, their address is, I think it's 122 Simon Drive. That's it. We didn't get a...
But elsewhere in the record, there were references to the fact that that street address was in Summit County.
There are, and Children's Services point out, I think, that there was a shelter care order that references that address and says Akron, Ohio. The issue is that Children's Services is required to bring in all of the testimony at adjudication. It can't piecemeal together its case by looking back and saying, well, the court can take judicial notice of a prior entry.
And you have just now reached into your 3 minutes of rebuttal time.
Thank you, Your Honor. I would simply use a little bit of my rebuttal time to follow up on that question and say, Children's Services points to this, I think it's the Fetzer case. That case is entirely different. That's a case that came out of probate court regarding an adoption and the consent of a parent. And the issue in there was that the parent had consented in a prior judicial entry about the issue of communication, which was the issue for trial. In this case, the client did not consent to, in the prior entry, his address for purposes of adjudication. They were there for the purposes of a shelter care hearing, and he stipulated to the facts of the shelter care. I would reserve the balance of my time for rebuttal. Thank you.
May it please the court, Kevin DiMartino on behalf of Summit County Children's Services, the appellee, we are asking that this court affirm the trial court's decision. With regard to the issue of venue, that is something that should be raised before adjudication. The case law indicates that that is a matter that should be brought up before adjudication. In this case, the agency would argue that venue was proper, the venue requirements were met. There's no dispute in this case that the children were removed from the residence that was in Akron. It was a Summit County caseworker that testified. The complaint was filed in Summit County. There's nothing to, in any way, shape, or form, negate that that it occurred in Summit County. Even in criminal cases, which has a higher burden of proof, the state can show venue by showing that an officer testified about the street, and then the county or the different pieces. They don't have to necessarily say this street address, which is in Akron, which is in Summit County, which is in Ohio. There's enough information in the record to establish venue that this child was residing in Summit County, the parents resided in Summit County, and the matter was not objected to, certainly not before adjudication, and that is when the case law requires that that matter be raised. With regard to the issue about prospective dependency, there is no case that says that prospective dependency is only limited to 215104C, and in fact, this court in NRA DB held that there can be prospective dependency under 215104C and D. So the fact that the statute discusses perhaps prospective dependency in Section C does not negate the fact that other appellate courts have extended that and found that, including this court, that it does apply to 215104D.
What was the name of that case again?
DB, 9th District case. I'll see if I can find the site while I'm talking.
Oh, that's okay, I see.
2003 Ohio 4526. With regard to the issue of not allowing Dr. Radiovich's testimony or reports to come in because the doctor wasn't the custodian, that argument doesn't honestly make any sense, to say that the person who created the record cannot testify about the record, that they can't say that it was kept in the ordinary course of business and that they created it at the time.
But she didn't say that, did she?
She testified that she created the record, and
Yeah, but she didn't say it was kept in the ordinary course of business or provide any of that foundation.
she didn't say that language, no. She testified as to what the record was and that she worked there. And if this court was going to hold that this privilege, the way it was articulated by defense appellant's attorney, then we would never be able to prove a case in dependency neglect case in children's services. We have to show there's case plan compliance. I don't know why I'm tongue-tied today. Case plan compliance, which often includes some type of psychological evaluation, parenting evaluation, etc. As part of the case plan, then their parents are to do whatever's ordered and then follow up. So if the parents are doing what they're supposed to do in order to get their child back, they would want those reports to come in. And the fact that they're involved in children's services, they have a case plan, it's court ordered, this exception applies, 2307 G1, I believe it is, that allows the psychologist to testify about what's in the report based on the fact that this was a CSB ordered case plan evaluation. So I disagree with the section that he's citing to. I don't believe that that's dispositive. I believe that we fall underneath G as opposed to section B. Are there any other, if there are no other questions from the court, I would rest on the brief.
Well, let me ask you a question, because now I'm finding this DB. It looks like we found that the child there was defended under C and D. So how does that change your analysis?
Well, he was indicating that you cannot have prospective dependency under D. If this court found it under C and D, prospective dependency, then there would have to be an ability to have prospective dependency under D.
Well, but haven't we subsequently said that you can't do that? That it has to be after the dependency has to exist at the time under C, but can exist beforehand because they are separate sections?
Right, it can exist because they're separate sections, but this court, he's trying to argue that you can't have it under D at all. And I believe that you can have it under D if the necessary findings are in there. And in this court...
You mean under C?
Under C.
Okay.
And the record in this case shows that both psychologists, the mother and the fathers, were worried about this child being with the parents.
Well, isn't that the purpose of having D then?
It is, I would argue that is the purpose of
And
having.
the court said there wasn't sufficient findings under D?
The journal entry? I don't recall if the court said there wasn't sufficient finding under D.
But it didn't find under D.
It didn't find under D.
So that's the whole point. I mean, so how do you, I'm not sure how you reconcile that.
Reconcile that there could be prospective dependency under different subsections.
Well, or just that the court said, you know, maybe didn't say I don't find it under D, but said I find it under C. So the implication is it's not sufficient under D. So how do you reconcile that to say it's prospective dependency under C, but not under D, which really probably is the appropriate section.
I don't recall that that was raised that way in the journal entry, and I don't believe that that issue was raised this way before the court. All the assignments of error have to deal with the exhibits and with whether or not there was weight of the evidence. I don't recall that there was any characterization of the argument before the court regarding whether or not a finding under D or C was an error. I mean, his first argument is venue, second, third, and fourth have to deal with 3 exhibits, and then the final argument has to deal with whether or not there was weight to show that the child was dependent. So I don't believe that that issue is properly preserved or before the court onto that argument as far as C and D and whether or not that was even raised before the court. So I don't believe that it's an issue for the court to consider. I certainly don't recall it being briefed at all. It's really been raised for the first time here, which would mean I wouldn't have had the time really to research either C and D or to see what the court specifically said through the record. I don't recall whether there was any argument back and forth about C and D or anything to that effect because it wasn't presented in the brief.
Thank you.
If there's nothing else, I rest on my brief. Thank you.
Counsel, you have just over 2 minutes remaining.
Thank you, Your Honor. To the last point, the Section D issue, D was dismissed, I believe, by the magistrate at the trial court level, and so was Section B, and that was not objected to by Children's Services to the trial judge, nor was it raised on appeal. So the Section D issue is not an issue on appeal. The only issue under which dependency was found was Section C. Again, in terms of a case, the case out there is the Ohio Supreme Court case of Henry Burrell, which says you must show an actual adverse impact. It can't be any clearer than that. And this court has made it clear in NRA OH, you must show an actual adverse impact, period. There is no prospective dependency under Section C. That issue was briefed, it's in the appellant's brief, and I would even suggest that the DD case, the Children's Services site, was overruled by this court's case in NRA OH, which came later on. With regard to the exception for the admission of the psychological testimony and evaluation, 4732.19 says that a psychologist's privilege stands on the same footing as a physician privilege. So we look under Section 2317.02b when we're dealing with whether testimony can come in from a psychologist and a patient. The last point that I would make in terms of if we don't allow this exception and the court construes it the way that I'm suggesting to the court to not allow in these medical records, first of all, at adjudication and permanent custody trials, that's what the legislature intended, because that's part of the due process protections built into the statute, that you can't just grab any medical record you want of a person when you're trying to take their children away and bring that into the court. In terms of the interim stages and disposition, the trial court has to decide what's in the best interest of the child. It does that based on the evidence that's presented. Once you get past adjudication, you've already determined that a parent is an unsuitable parent by virtue of having the adjudication. So the burden then shifts to the parent to demonstrate that it now is in the child's best interest to be placed back in their legal custody.
Counsel, you can probably reach the end of your allotted time for today.
Thank you, Your Honor.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which we mailed to both sides as well as posted on our website.